Hopefully I don't need it, Your Honor.
You're reserving 3 minutes?
I am, Your Honor.
Okay.
Good morning, Your Honors. May it please the Court. Your Honors, my name is Caleb Rackley, and I represent the Norman family, specifically Sasha and Shane Norman, individually and as an ex-friend of their minor child with the initials SN. The child was, as you know, Your Honors, was burned age 5 and was severely burned when a coffee press manufactured by Bodum shattered and exploded.
Well, you point to them, but they're the distributor, right? Part of the problem here maybe is this is manufactured in Switzerland or Portugal? Is that's
Well, Your Honor,
is there a discovery component to this issue or not?
Well, the first question, I don't think that they claim to not be the manufacturer, but what's important to remember, Your Honor, is that they initially laid out an innocent seller defense and then dropped that. They stepped into the shoes of the manufacturer, and the court below did not exclude. It was the exclusion motion was dismissed as moot, but there's evidence in the record as to Bodum AG, appellee, being involved in the manufacturing process. Extensive evidence about them being the eyes and ears of the overall operation, such that when there were manufacturing issues that had come up in the past or complaints, Bodum AG was heavily involved in resolving those manufacturing issues. So our position is that Bodum AG is in fact the manufacturer. Now, as to the discovery issue, we asked for manufacturing specifications, design specifications, and they said, well, we don't have them. And I think that goes to a larger sort of policy point that I was going to get to in a moment, but I'll go ahead and address it now, which is that it just can't be the law, in our opinion, in the Fifth Circuit or anywhere, that a manufacturer can simply say, nope, we don't have the design specs, and no design specs, no claim, you're out. In this case, there's a ton of evidence that is in the record.
Well, I guess the law is Texas law, and what does Texas law accept as circumstantial proof of a manufacturer's specifications?
Great question, Your Honor. And first of all, one of the things that we do in our briefing is we point to case after case after case that says, number one, you can prove manufacturing defect, and also, more specifically, deviation from intended design with strictly circumstantial evidence.
And you think you created an issue of fact with the circumstantial evidence that you've listed in your brief?
Absolutely, Your Honor. And
what's the strongest piece? Is it the manuals? Is it the CEO? Is it the exemplars, the patent pictures? Which one do you think has the strongest basis in existing law?
You know, it's kind of like asking me which of my kids is my favorite. I mean, we believe that all of it's wrong. But I would say, to me, the exemplars. You know, one of the things that the court below, in our view, did improperly was they said, you know, just there wasn't enough of a sample size there to make a difference. The court cited to no authority for that. And of course we pointed that out in our briefing, and then Bodum in their briefing, they pointed to a case that simply was not on point at all. I think the case was Sparling v. Doyle, and in that case it deals with it's a Dalbert issue, and it deals with whether a scientific study produced, whether there was a statistically significant result in that scientific study for it to constitute a basis for reliable testimony. Well, that's completely different than what we have here, which is a summary judgment context where all we have to do is raise a fact issue, and it was involving exemplars. It seems to us there's no...
You think you got past summary judgment without even reference to expert Lingnell? Is that his name?
Well, I think we did, but I would say that Lingnell's testimony is also certainly helpful, and it was not excluded. But yes, absolutely. Between the exemplars, the warnings, one of the things that Bodum kind of, I think, sort of makes fun of us in our briefing, saying we emphasize Glass 101 too much. Well, there's a reason we did that, because it's kind of like the Texas Supreme Court's landmark case, American Tobacco v. Grinnell, where they said, the Texas Supreme Court said, look, no manufacturer would have intended to put pesticides in their cigarettes. And therefore, that was circumstantial evidence of a manufacturing defect, of deviation from intended design, the fact that those pesticides were there. Same thing here, Your Honor. I believe you have a demonstrative, one-page exhibit in front of you. I'd given it to, no matter, I'd given it to the clerk, but basically it's just a picture of what you see in the brief of the subject product where the coil is extending outward toward the glass carafe. Well, that can't be what was intended, right? Because one of the things the expert pointed out repeatedly was that in the glass business, that's the cardinal sin, right? You can't have rigid metal scratching against softer glass. And so I do think also.
Remember what the district court got on the web and said, oh, here's a picture and it looks like it's outside the mesh, so at most you've got a manufacturing design.
So that's a good point, Your Honor. But to clarify, that picture did not have the mesh, right? That picture was a picture of just that single component with it's a disc with the spring around it.
No mesh in it.
And no mesh. So it shows that protruding coil. Okay, and so I guess the argument would be, well, does that suggest design defect as opposed to manufacturing defect? But there's 2 points there. One is that there was an additional part of the defect, right? It's not just that the coil was protruding, it's that the protective mesh, and when you see in that picture of that subject product, the protective mesh is deteriorated and deformed downward so that it's no longer protecting against a possible protrusion. And so that picture did not include that mesh. That's one point. The second point is I think the court below was sort of suggesting that, well, that picture on the website suggests some sort of systemic defect. Okay?
Some do, some don't.
Right, and so I mean, we clearly don't have a systemic defect here, right? We have because the exemplars prove that's not the case. What we have is I
see two possible narratives, and I'm curious which one you adopt. One is, I think you've suggested here, they clearly designed not to have this protrusion. That's your Glass 101 point. But there's another possible narrative, which is they didn't really think of it one way or the other, that they were myopic as to this.
Well, I think, Your Honor, the key on that, it may be that the most significant part of the record here is what's not in it. Think about it. If Bodum wanted to put the nail in the coffin on a summary judgment on manufacturing defect, why wouldn't they have submitted as summary judgment proof the design specs that showed that the subject product was in compliance? That would have done it. But they didn't do that because it can't be the case. I mean, that suggests, at least raises a fact question at least, that the design specs did not show a protruding spring and a deformed mesh. Does that make sense? And so, I guess I can't emphasize that enough.
So they're intentionally refusing to disclose what they have?
What they are saying is that they are again, after dropping the innocent seller defense, they're now saying that they simply do not have it because they are not the manufacturer. But in reality, their parent company clearly is the manufacturer. We have evidence in the record that says that Bodum AG, the appellee in this case, participates heavily and is a vital part of the manufacturing process. But the idea that appellee couldn't get their hands on those specs is crazy. There's extensive testimony from the CEO saying that he is heavily involved in the Appley's role as the eyes and ears of the overall process. He travels back and forth to the parent company in Switzerland and in
Saying
Portugal.
the manufacturer is Bodum AG?
That is our contention, yes. The manufacturer is Bodum AG. It is a subsidiary. I'm sorry.
Go ahead.
I may have misspoken. What I meant to say was that Appley, Bodum USA, is the manufacturer.
Okay, that's why I'm asking.
Yes, so if I misspoke, if I said Bodum AG, I meant to say Bodum USA.
Your contention is Bodum USA Inc., the sole defendant, sole appellee in this case, they're the manufacturer, and they should have had these specs.
Yes, Your Honor.
Did they give a reason, pardon my ignorance, did they give a reason as to why they didn't disclose it? Just simply they're not the manufacturer?
You know, they said we don't have them, and of course in their briefing they suggest, well, you could have gone through third-party discovery to a foreign, a Switzerland company. Well, and I suppose we could have done that, Your Honor, but we didn't need to do that. We have raised a fact issue, and our intent was to go before the jury and say, you got these two pieces here. You got the one that caused the injuries, and is it protruding? And then
What's your fact evidence that they manufactured it?
So Your Honor, there's extensive. There's the testimony. It's the expert testimony, Your Honor, from Dr. Linnell. He submitted a supplementary report that is in the record, and that is And one of the things is,
How would he know which corporate entity is the manufacturer as opposed to a distributor?
well, he has spent a lot of time in part of his over 50 years experience in the glass industry. He was involved in company systems, and in that report he talks about how Bodum USA played a vital role in the manufacturing process. And he describes in his expert opinion why that clearly is the case. But even setting that aside, right? I mean, the reason this is an issue is because the specs aren't in the record, right? The manufacturing specs, and our position is very clearly if we haven't raised a fact issue on deviation from intended design, we just believe that we have, and I think it would set a bad precedent if all of the things that we've shown between the expert testimony, the exemplars, the warnings, the manufacturers, the owner's manuals, the patent documents, the admission of Bodum's CEO, all of those things, if that's not enough to raise a fact question, you just have to wonder if the district court properly weighed all the evidence or viewed all the evidence in the light most favorable to the appellants in this case.
Do I understand Bodum USA Inc. is the only defendant you sued?
That is correct, Your Honor.
But there's apparently another entity known as Bodum AG?
There is it is a Switzerland company. That would have had...
USA, the sub of the AG?
I'm sorry?
Is USA
Yes,
sub of the
yes, Your Honor.
of AG? Okay.
Yes, Your Honor. And one thing on the
What's your evidence that USA is the manufacturer and not AG?
Again, Your Honor, it would go to the Lingnell's testimony, where in his he lays it out in that supplemental report. And one thing to keep in mind is there's obviously the report, the testimony, the declarations. Those are all a part of the record. None of it was excluded. And even there's not a hearsay objection to my knowledge anywhere in the record. So the report, the supplemental report, the declarations, those are all summary judgment evidence that in fact the court actually relied upon. At one point the court, I think on 2 occasions, at least once, the court actually quotes from the court below quotes from the expert reports. So those are a vital part of the record, and in there Lingnell lays out why, in his expert opinion, Bodum USA was a vital participant in the manufacturing process. One thing I did want to point to, Your Honors, this is important. There's the Cooper Tire case, which of course, Judge Willett authored when he was on the Supreme Court. It talks about how the plaintiffs in that case could not eliminate the possibility of a design defect. And naturally, the appellee sort of really emphasizes that. But we have done that, Your Honor. We have shown with evidence after evidence after evidence that there is a deviation from intended design, and that's how you eliminate the possibility of a design defect. And I also wanted to emphasize the warnings. You know, in Bodum's own literature, it talks about, there's two separate warnings that before you use the product, you come across two warnings that say, you know, I'm paraphrasing, but it basically says, you know, under no circumstances can you have metal to glass contact. You can't use metal spoons. That will weaken the glass. And so that constitutes an admission on Bodum's part that, you know, despite them criticizing us for emphasizing Glass 101 so much, they emphasize it in their own literature. And so that's a vital part of the evidence.
So you're saying the Glass 101 is not just him saying, believe me, it's something capable of testing, it's a scientific view?
Absolutely, Your
And
Honor.
it's not speaking to the manufacturer's intent. It's just his opinion.
No. I think it's his opinion about the manufacturer's intent. Absolutely. And look.
Opinion about the industry, like everybody would do it this way, is what you're saying, right?
Correct. Like you would never have this. Yes. And more specifically to this product, obviously. But
Your time is running out. I'm going to ask a question for both sides to think about.
Yes, Your
in the
Honor.
event that this becomes an issue. Hypothetically, because I'm not sure I understand this. Hypothetically, if Bodum AG is the right defendant and not Bodum USA, obviously I invite folks to tell me that that's correct or incorrect. But if that were the case, do we affirm or do we reverse and remand and then let you all sort of amend the complaint in the district court? Does that make sense what I'm asking?
yeah.
Because it's not clear to me, this defendant issue. Maybe that's the problem.
Yeah. So as between those, should I answer now or should I wait for my time?
Take all the time you need to answer that question.
Okay. So as between the two options, well, we would say certainly you should remand, but there can be more than one responsible party, right? If Bodum AG hypothetically were partly liable, that may be the case, I suppose.
Wouldn't there be one manufacturer? And again, pardon my ignorance as to this area of law.
No, Your Honor.
Somebody manufactured this thing, right? And let's say you're right, that there's a defect. Everybody would have designed it one way, and they obviously had a flaw. Somebody did that. Why would two companies work together on the same manufacturing process? Because
and it's a great question, Your Honor. And if you when you go in and you can see it in the record where there's extensive testimony not only from Lingnell, the expert, but also from the CEO, where he talks over and over about how that he's working together with Bodum AG to address manufacturing issues and to help solve manufacturing problems. You know, there was
joint venture of some kind, essentially.
They're working together. I don't know what the actual technical details are as far as the corporate relationship, but clearly there's a close, tight relationship. And the CEO talks about how because it was in an answer to questions about prior incidents where there have been these sort of similar accidents. And he talks about how what he was involved in to try to address those issues and improve the product so that it wouldn't do that.
Was there a reason you didn't sue both? Was there a jurisdictional or other?
Your Honor, we felt like and we believe that we have the evidence to go to the jury against Bodum USA. To go to involve Bodum AG would have involved going through The Hague and all kinds of stuff, and we simply didn't think that we needed to do that.
Counsel, you've saved 3 minutes for rebuttal.
Yes, thank you, Your Honor.
Okay. Mr. Wheeler.
Thank you, Your Honor. Good morning, may it please the Court. My name is Jason Wheeler, and I'm here on behalf of Defendant Appellee Bodum USA. I'm reminded this morning of the old aphorism that no battle plan survives contact with the enemy. So rather than go through what I was going to start with, let me address Judge Ho's question first about the proper party. And frankly, these are fact questions that are easily resolved. First and foremost, the relationship between the parties is demonstrably true and accurate and is available on the internet. Okay. Bodum Holding AG is a Swiss company. They're the parent. They're located in Switzerland. Bodum USA is located in New York. They're a subsidiary. They're a separate, independent company. They maintain the corporate form. There's never been a challenge about that. They are the sole exclusive distributor of Bodum products in North America. That's it. Now, the problem, I think, and it's kind of a semantic issue, I think, a discovery issue, but not a substantive issue, they are not the manufacturer. There is no fact in the universe, let alone in this record, that could make Bodum USA the manufacturer of this product. They are not.
Who is the manufacturer?
The manufacturer is a separate affiliate subsidiary, which is called Bodum Portuguesa. It's located in Portugal. And again, all this is available. And again, I want to make sure that we're clear on this because, a lot of things were said. This case arises, and I want to make sure I get my facts right. Okay, from an accident that happened in November of 2018. It involved a French press that was purchased in the summer of 2016. So it had been about 2 years of almost daily use of this product before the accident. Suit was filed in May of 2019. We filed an answer in June of 2019. That's in the record. It's started at page 30. Right there, they sued Bodum USA. We told them right up front, we're not the manufacturer. We didn't design it, we didn't manufacture it. So they had notice immediately within a month of filing lawsuit. Judge Rodriguez orders the parties to have a Rule 26 conference, of course. During that phone call, and I was counsel of record down there, so there was me on the phone. I knew this was going to be an issue. I've done this before. I have a lot of European clients. I knew this was going to be an issue. We raised the issue affirmatively. I told Mr. Watts, which was appellant's trial counsel or the district court, that they named the U.S. subsidiary in North America. They do not have design and manufacturing documents. I told them who did. I told them where they were. I told them that we would help cooperate with international discovery to comply with The Hague, but not just The Hague, but more importantly, Swiss law. If this court has familiarity with Article 271 of the Swiss Criminal Code, commonly known as the Swiss Blocking Statute, it could make Bodum AG criminally liable for voluntarily participating in a foreign tribunal through the voluntary provision of documents, okay? We told them this. We wanted those documents too, but we had to protect the corporate form. We had to protect the client's, or at least the Swiss entity's rights, so we disclosed it as early as we could to make sure that plaintiffs had plenty of time, that if they wanted them, they could go get them. And there's a statute, 28 U.S.C. 1743, allows for the issuance of subpoenas against third parties in foreign countries. Rule 46 allows it as well. The law provides a mechanism for this. They could have done that. Now, the other option is, in January, when we responded to discovery, and I actually have them here, because they asked about all these things, okay? Who's the designer,
Where's this going? Because you're not saying Texas law doesn't allow circumstantial proof.
No,
Might be
Your Honor,
best
I think
to
that's...
have the best evidence, but the issue before us, I thought, is an expert admissible on this? Was Judge Rodriguez right or wrong to discount the various circumstantial proof they offer?
No, Your Honor, our position is that Texas law certainly allows circumstantial evidence under certain circumstances to prove any number of different elements of different types of claims, as long as the circumstantial evidence is competent and sufficient to answer the core questions that arise from the cause of action.
Rodriguez thought about the exemplars. He said too small a sample.
100%. And again, I will commend the court to Judge Rodriguez's opinion, which we believe is well-reasoned, applies this court's law, which includes two opinions written by two of the panel members today. We've got Casey. We also have Cooper Tire. That is an accurate statement of the law. This court addressed these issues in 2014 in Casey. There's been no significant developments or changes in the law since then.
Well, what got me confused reading his opinion is he ultimately seems to say not that their circumstantial proof doesn't show a deviation. He actually says the opposite. He says this is a design defect because I've looked at the website and there it is protruding. Are you defending that aspect or am I misstating?
I think there's a factual misstatement that's easily to correct. The plaintiffs put into the record the photograph of a Bodum French press that they got from the Bodum website, which showed the position of the spring in the exact same protruding, what they contend to be a deviated condition. Judge Rodriguez pointed to that evidence that the plaintiffs themselves put into the record as saying, well, look, how can that be evidence of deviation of manufacturer's intent if the one that's on the website that they're trying to sell to people looks exactly like the one that they claim was out of position? That was his point. So that was their evidence that they put into the record. Now,
That's not something you've endorsed, that it actually is designed that way with the coil on the glass.
So, Your Honor, I don't want to make the same mistake as counsel below did and put myself into the record. But I can tell you that if you ever used the French press before, certainly a Bodum French press, that steel spring has rotational freedom of movement around the axis, okay? Which means that it can rotate left or right a little bit. Sometimes, depending on when you look at it, it could be tucked underneath. You look at it again the next day after using it, it could be rotated around the axis a little bit. The position that they claim is a deviation is just simple variation, and variation is not deviation. Certainly not on this record, not without more proof. And that's why the circumstantial evidence fails, because what they're asking for and what they complain about is Judge Rodriguez not giving them all the inferences they think they're entitled to at summary judgment. But Judge Rodriguez's opinion, which goes through each of the cases, goes through all of the evidence, basically says, look, you can give all the inferences that you want. The question is, could a reasonable fact finder determine what the manufacturer's intention was with respect to the position of that spring? And because we're talking about such a small piece that has rotational freedom, who's to say whether that particular space is 1 arc degree off, 2 arc degrees? What's the variance allowed in the manufacturing specifications? There's no evidence in the record on that. Our position is that, if you ask me, I will tell you that it's just, there's nothing wrong with it. The manufacturer wouldn't have thought twice about it being in that position because it has rotational freedom of movement. And that's the end.
When you say rotational freedom of movement,
Yes.
you're saying somebody could touch it and move it so that it's protruding now, but now it's not protruding as you move it around.
Yes. The
So then
simple act of moving it up and down the carafe during use can
So is the idea then that what really matters is having a protective mesh around it so that it doesn't scratch the glass? Is that the issue?
Well, I guess our position would be that it doesn't matter in any event because there's zero evidence of any kind of contact between this piece and the glass. That's what issue we raised in our brief. That's an independent basis to affirm Judge Rodriguez, the absence of proof of contact, which destroys the entire causation model. Even if there was contact, and you heard counsel mention time and time again, it's all over their briefing, that metal on glass is per se a manufacturing defect because we tell you not to do it. And yet, as Judge Rodriguez himself noted, the manual specifically says it's fine to have metal on glass contact because the mesh is metal every time you use it.
Is what?
The mesh protective, well, a couple of things. It's not just a protective mesh, okay? The spring sits inside the mesh, but what it does is allows for there to be a seal. Now remember, what makes a French press coffee maker unique among all the the coffee makers is that it allows for continuous contact between the coffee grounds and the water throughout the brewing process. Not filtering, it's not passing through, it's not pressure. It sits in the water for 4 minutes. Now, in order to make it drinkable, you have to collect and trap all of the coffee grounds at the bottom. And so what that wire mesh does isn't just, well, I'm not even sure it actually does protect the glass from the metal. What it does is it creates a seal against the side of the glass to make sure that all the coffee grounds get pushed down to the bottom. Otherwise, you pour it out, you're drinking a mouthful of coffee grinds. So again, I don't even think there's any evidence in the record of the manufacturer's intention that that mesh is intended to protect against contact between the spring and the side of the glass. All of which is, of course, academic because there's zero evidence in the record that even with the protruding spring, there was contact with the glass. And I will point out, just because it is an interesting evolving theory, and it goes straight to Cooper Tire's critical distinction, evidence of intention is critical, because that's what helps rule out a manufacturing defect from a design defect. A reasonable jury could, we don't think on this record, there were lots of issues raised at the district court level that the court correctly ruled were moot, which are primed and ready to go if we go back down there, but we raised them. But for purposes of this argument, let's assume that a fact finder could find that that protruding screen was a defect and that it did cause this thing to fail and injure the little boy, which is tragic, of course. That doesn't answer the critical question on a manufacturing defect claim, which is, well, was that intended or not? Even Mr. Lingnell's own opinion on this, which mirrors a couple of cases from the Texas appellate courts, which we cite, De Los Santos, and the other one is, if I get it right, the iLight cases, which we cite in our briefing, where the expert basically says, no manufacturer in his right mind would design it this way. I think in just De Los Santos, it was there's too much phosphorus in the steel. Nobody would ever do that. Okay, well, maybe that's true, but maybe they did it anyway, which makes it a design claim, not a manufacturing claim, okay? Even this, and again, I don't want to go through each of the cases. I will rely on our briefing on this. I will rely on Judge Rodriguez's excellent opinion on this. He goes through all the cases, we do too. They're all distinguishable. I mean, for the proposition that circumstantial evidence can be sufficient, sure. It can be, but it's just not here.
So take me through the pieces of...
Sure.
So one is the exemplars, and
Okay.
that's too small a sample. What's the best authority to support that?
So it's, like the cases in the briefing.
If it's in the
Yeah,
brief.
it's in the briefing. But it's also, and I would submit that even though this court sits as a de novo review, I don't think, in my own personal opinion, Your Honor, I respectfully submit that it's not reversible error for a district court judge when reviewing the evidence to say that if you're giving me evidence of 5, and 2 of those 5 actually are consistent with what you contend to be a deviation from manufacturer's intent, the other 3 weren't even addressed in that way in the expert's report. They were brought up later and after the fact when the plaintiff realized they had a great big gaping hole in the middle of their claim that they needed to fill at the summary judgment stage. And again, I don't want to burden the court with the record, but almost all of this evidence was not produced in discovery. Now, I'm not suggesting you should, make an evidentiary ruling here.
Going through, then
Yeah.
they say the CEO...
So let's do that. So there's pictures, like little pictograms, okay? There's one from the manual and there's one from something they got off of the website. Well, those are just 3D or 2-dimensional representations of what the piece looks like so that people know which piece it is, how to assemble it, because you're supposed to disassemble it, clean it every time you use it. No indication whatsoever that the manufacturer intended, so there's 2 layers of inference required here. One, that they intended that pictogram to show anything about what the coil's position should be, or that it was intended to convey any information at all about a design specification or a manufacturing specification. In fact, if you look at the manuals themselves, they're very clearly just intended to tell the user, this is how you use it, this is what it looks like, clean it every time, don't use metal spoons. That's the kind of metal they're talking about because you might chip it if you're stirring it too hard. Those are the pictures, and Judge Rodriguez correctly said, look, whatever inferences I can give you, there's no evidence of manufacturing intent with respect to the position of the spring. That's the pictures. The ornamental design patent, I think, is easily addressed just by looking at the case law that tells you what an ornamental design patent is. I'm not a patent lawyer, but I know enough to tell you that there are 2 different types of patents, and an ornamental design patent is not the right kind. It's not the right one to tell you.
So what is an example of circumstantial proof? If you're beginning to suggest you've got to be in the state of mind of the manufacturer,
Sure.
It all comes down to intent. When would you ever have what would be an example of valid
Well, it's a case-by-case analysis.
I know, but just give me a good one.
So in this
If
case,
it turns out the manufacturer's defunct from Nigeria, you couldn't get the specs.
couldn't get them. They don't exist, and you've got a product. Now, it depends on what the product is. There's cases that talk about
Just an
sealed
example.
systems, right? In a case like this, if you wanted to establish manufacturer's intention circumstantially, I think the best and perhaps the only way would be to do a statistical sampling of enough exemplar products that would actually allow an expert who did a statistical analysis with correct p-values, did the right calculations, and said, I examined 100, or whatever the expert would say. I mean, that's really an expert question.
I mean, that's presuming a state of the world in which most of the product was designed to spec, but just a small percentage
Sure.
was defective. You could have a different situation where 50% of the products off the line were manufactured defectively.
As a hypothetical, Your Honor?
Right. I mean,
Oh, yeah,
I'm just saying, like, based on the percentage of products.
But
that
even in that
diverge,
case,
I don't know if that tells you which line we're going now.
Right. And I think even in that case, you might have a problem here, because if 50% of them are coming off the line this way, it's hard to imagine the manufacturer not knowing and not intending it. Okay? And again, I don't want to lose sight of the fact that the circumstantial evidence requirement...
Not necessarily. It depends on whether it matters to the manufacturer.
Of course, but that's why the evidence...
In fact, that doesn't create harm.
And that's why the evidence of intention is so critical. And it may very well be that circumstantial proof of a manufacturing specification is inherently difficult, especially if you don't have the specs, because the key and defining element of this claim is comparison to the intention and showing deviation, which is why the law affords you many other remedies if you can't prove a manufacturing defect. You can get an expert to come in and say it was designed this way. You don't need the specs to do that. You can just take a look at it. And frankly, in this case, they're going both ways. They abandoned the design defect claim. And even just 10 minutes ago, counsel comes up here and says, well, no, hold on. Part of our claim here is that the wire mesh had degraded, and that allowed contact. Well, That's not a manufacturing issue. That would be a design claim because this thing was 2+ years old, had been used almost every day. That's almost 1,000+ times, or 600 or 700+ times. If the evidence is that it should have been more robust, if it should have been able to withstand that without degrading, and there was some evidence of causal, then that's not a manufacturing issue, that's a design claim. So if that is part of their claim, well, that just proves our point. Okay, you can't tell the difference, and not even they can tell the difference. So how could a reasonable fact finder tell the difference? Also, they point out that Mr. Lingnell submitted a supplemental affidavit. That's being generous. He submitted 2, and they were all after the close of discovery, submitted solely to respond to summary judgment. That's fine. We're not making an issue out of admissibility right now. We'll take him at face value. But what he did in his last declaration, and this is critical, and this is raised in our briefs, and frankly is almost as dispositive of intent, as the picture from the website that shows what the manufacturer clearly cares and doesn't care about. If that protruding spring is what they're showing to consumers as being fine, then that's the best evidence of whether they care about it or not. Certainly no deviation. What Mr. Lingnell did, Mr. by the way, not doctor, what Mr. Lingnell did in his last declaration was try to fix a bunch of mistakes that he had made in the earlier reports that he'd made. And he went a bridge too far. Because what he basically said is this: glass has tensile strength. That's the strength of force it can withstand before it'll break. This is borosilicate glass, by the way. This is Pyrex. This is not soda lime glass. This is stuff you use in chemical, industrial manufacturing, academic laboratories. This has a very low coefficient of thermal expansion. It's very, very strong. Okay, that's why we use it. It's Bodum, not a knockoff. What he says is that over time, all glass can break, and that as time passes, the inherent tensile strength, for no other reason than just use, can degrade. So he calculates, and again, I'm not agreeing with any of this as a fact matter, but we'll assume it to be true for this argument. He assumes in his first report that the tensile strength of the glass is 17 pounds per square inch. That's how much pressure it can withstand. Now, the theory, again, is...
This is on causation now?
Well, it's on causation, but and we did raise causation in the brief. Yeah, yeah.
This court didn't rule on that.
Well, he didn't rule on it, but it's an independent basis supported by the record. Yeah.
Is that what you're urging now, an independent basis, or because you finished?
Two parts. Yeah, no, there's 2 parts to it. One, it is an independent basis, so yes, to answer your question, Your Honor, definitely. But 2, it underscores the need for robust circumstantial evidence because the nature of the deviation is so small. I mean, it's not like the airbag did or didn't deploy. It's not like a seatbelt did or did not, or any other example we could
He
give.
cites American Tobacco. He's saying you wouldn't ever put pesticide in a cigarette. You would never have a sharp little edge against
Yeah,
the crowd.
but see, the problem with American Tobacco and the Grinnell case is that everybody agreed, including the defendants, that there wasn't supposed to be pesticide in cigarettes. So there was no issue of manufacturer's intent. It was conceded. There was.
Your point is it's not a big deal that it protrudes because all you do is rotate it slightly and it will protrude. It's a mesh that.
If you're asking my personal opinion, I would say no, it doesn't matter. If you're asking me what the record says, I would say there's no evidence that the manufacturer would care. And again, the best evidence is that they had one from the website, not a pictogram, not an exemplar. This is the actual one they're selling, same position.
In Cooper, but is it really whether the manufacturer would care, or is it just what is the output that comes out?
It's intention. I think Cooper makes clear.
On that it's state of mind rather than looking
Yeah,
at the output.
I would point you again to Judge Willett's opinion in Cooper and Your Honor's opinion in Casey, which is still the very best law in the state of Texas on this issue. There's nothing since then, since 2014 in Casey. And again, I don't want to pander, but it's an excellent recitation of the law. It rules out a bunch of the arguments they're making about malfunction inferences, and it talks specifically about the defining element of a manufacturing defect. It's what makes it unique among all product liability claims. It's deviation from intention. What was the intended output, planned output, specification? Call it what you want, but the point is, what did the manufacturer intend? Because if the product isn't what they intended, then sure. If it's a defect that caused the accident, then the law should provide them a remedy. If it was intended and it still caused the accident and the jury finds it to be unreasonably dangerous or defective and they can check all the other boxes under Texas law, alternative design, et cetera, then sure, they have a remedy. But they went all in on manufacturing design. And to answer the other side of your causation question, Judge, is that it also goes to the sufficiency of the circumstantial evidence, because in order to establish the causation, they have to establish a deviation. But the deviation is so subtle and small, as I mentioned, and the contact between the protrusion, alleged protrusion in the glass, is non-existent. There's no evidence in the record, because again, I've got 10 seconds left, and I want to be very quick about this, because this is important, in my opinion. In order for them to be correct, this thing had to be out of position in such a way that the manufacturer would recognize it as a deviation from planned output or specification. Had to make contact with the glass, had to scratch the glass, the scratch had to be big enough, significant enough to actually weaken it to the point where it would fail. All of which would be on the inside surface of the glass, because it's, a 2 millimeters thick, so it's got an interior surface and exterior surface.
Wrap it up. But we have read what the two experts said.
Yeah, and so we're not relying on, nobody has to make a decision on the experts one way or the other, although I will commend you to the record because there is.
Wrap it up, Counsel.
The last thing I will say to answer your question before is, well, let's put it this way. We commend the court to Judge Rodriguez's order. We believe he applied the law correctly, he viewed the facts correctly, he gave them all the permissible inferences the law would allow, and we respectfully submit that he should be affirmed. Thank you.
What is your evidence in the record that there was actual contact between the coil and the glass?
Right. So in both the report and in the deposition testimony, the expert describes how he repeatedly took the press mechanism from the subject product and inserted it into the carafe, the exemplar carafe, and the protrusion of the coil without the protective mesh protecting it lined up exactly where through his observation, testing, and analysis, he determined the fracture began. He documents in his report, and he discusses this at one point in his testimony, how he observed a surface crack, there was some question and answer back and forth about, well, why didn't you take a photograph of it, et cetera, et cetera. I suppose the expert may have wished he had done that, but nevertheless he documented it, and he demonstrated, the last thing, Your Honor, is that he demonstrated that in fact, he testifies to this, that the protruding coil would contact the glass. And the one point that Counselor made was, he talked about how, well, the mesh is metal too. No, that mesh is a very soft, flexible mesh. When those warnings that are in the product literature talk about how you can't let those metal spoons touch the glass, they're talking about rigid metal, exactly the kind of metal that protruding spring is. And so it's not a defense to say, oh, well, the mesh was metal too.
But what's your larger response to his that you didn't have any evidence as to the manufacturer's intent, whether they would have cared or not?
Yeah, Your Honor, I do think that the manufacturer's intent matters, and I would refer you to our reply brief. I mean, it lays it out step by step by step. As just the best evidence, Your Honor, is the February 2nd, 2021 declaration, which not only was not excluded, it was never even objected to. There was no motion to strike on that declaration.
And it says,
and it says right at the top, the manufacturer did not and would not have intended this protrusion because that's essentially, I'm paraphrasing, but that's the cardinal sin, and that would weaken the glass and cause it to break under normal user conditions. One thing I would also say, Your Honor, is...
Cut him off pretty quickly, so just make your summation. Go ahead, go ahead and make your one point, because he was able to.
Your Honor, we believe that we have raised a fact issue.
Okay.
That's the number one point. Thank you.
All right. And that concludes the cases for today. We stand in recess until tomorrow morning at 9 a.m.